Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. We have a panel of experts assembled ready to deal with a topic that we think will be of interest to you. The way this really is going to work well, though, is if you join in our conversation. You'll see ways at the bottom of the screen where you can communicate with us. We'd love to hear from you all throughout the program tonight. Also, for the amount of time that the show is on the air tonight, attorneys from Hollis Wright are going to be standing by live, actual attorneys standing by live to take questions from you. So if you'd like to get some free, confidential, off-air legal advice and run an idea or a question by an attorney, that opportunity, you take advantage of that tonight all throughout the program as well. So leading our conversation from the firm of Hollis Wright, Carter Clay. Good to see you, sir.
Good to see you, David. I hope you're doing well.
Doing well, thank you.
Yeah, tonight we're going to be talking about probate court. Right. And probate court is part of the Alabama state court system. To differentiate it from the federal court system, it doesn't have anything to do with federal court. It's part of the Alabama state court system. And we're going to be talking about the different types of cases that go before the probate court, kind of what you can expect from the probate court if you ever have a case in the probate court system, how long it will take, right. Activities that you might have to participate in, hearings that you may have to go through, and those types of things. And we're very fortunate tonight to have Peter Wright, a local attorney here in Birmingham, with us to share some thoughts and ideas about the probate court system, the types of cases going before the probate court, because this is an area of your legal practice at Sirote law firm here in Birmingham, and it's something that you've been involved in for many years. Is that right?
It is. I was counting the years up, been at it for about 25 years now, and been in the world of probate and estate litigation and administration for about 23 of those years. So I've been doing it for quite some time.
Wow. Now, does each county within the state of Alabama have a probate court in the county?
Each county in the state of Alabama does have a probate court. And we can talk later or however, and there are a few counties that actually have some extra powers, but all 67 counties do have probate courts.
And I was struck when I got out of law school and started practicing law, I didn't realize that you don't actually have to be a lawyer to be a probate judge, with the exception of two counties. Is that right, Jefferson County and Mobile County, or has that changed?
That is generally correct, but I will tell you that there's a Shelby County, typically a lawyer is serving as a probate judge, and we also have one in Pickens County as well, and I believe there is one in Houston County, but the two principal ones are Jefferson and Mobile by statute.
Well, and I was always struck by how well versed, on the few times that I've had to go before a probate judge that I knew was not a lawyer, how well versed they were in the law and how well read they were on it, given the fact they hadn't been in law school. Particularly
if you get into some certain counties where a probate judge has been doing it for 30 years, be careful about thinking you know more than that probate judge. On the flip side, there are some new ones there.
Correct.
And throughout, we got 67 counties, and I've been in some courthouses where they welcome some assistance and some information, but they will always do their job.
And most of the time, those new judges, they do lean heavily on the attorneys, and they'll tell the attorneys up front, look, no funny business, I want it straight from both of you, help me kind of navigate my way through this.
That indeed does happen a lot in our business, particularly with complicated cases. Now, and you know, they're not going to give it to you hook, line, and sinker, but they will certainly look for guidance and some assistance and to help make a proper decision in the case.
Well, talk a little bit about what types of cases are going before a probate court.
Okay, well, a probate court, probably one interesting thing about a probate court is it has a broad jurisdiction of what they deal with. The typical, the most traditional is a deceased person and the probate of a will and the administration of a will. When we die, we often have wills that are called last will and testaments that govern and tell people in a court of law how they want their assets to be handled, administered, and ultimately distributed to beneficiaries. That is the most traditional and widely used aspect of our probate courts, I would say, throughout the state of Alabama and probably throughout the country. But these courts also certainly we deal with in what's called intestacy administrations as well, where we don't have a will, or the decedent doesn't have a will, and there are statutes in place that tell a court and tell the beneficiaries and a personal representative, the person in charge of estate, how to disperse and split up the property among a surviving spouse, kids, next of kin, whatever it may be. But these courts have a broad jurisdiction. They also deal with guardianships and conservatorships, which are where you're dealing with an incapacitated person or a minor who needs somebody to be in charge of their person, their personal welfare, or somebody to be in charge of their property because they're unable to handle it themselves. And they also deal with elections, and so it can get quite political in some counties and handling those elections. They also deal and are the recipient of the land records, so they have a lot to do with real estate as well. So they have a very broad jurisdiction, but principally speaking, it is wills for deceased persons, getting those probated, handling that process, and making sure the assets of a deceased person are properly administered pursuant to the terms of a will.
And I remember during the campaign between Judge Roy Moore and Doug Jones that the TV stations were doing cut-ins and were interviewing Judge Alan King, who was one of the probate judges here in Jefferson County, and he was giving updates about the votes coming in and where they were coming in from the different municipalities and those types of things.
Right, in Jefferson County, you're speaking of Jefferson County, of course, and that is a very big county, a very important county for elections. So in many cases, people will overlook that role, and frankly, you know, I'm a fan of Judge King and what he does with those elections. It is an enormous amount of work that these probate judges oftentimes have to do to set up the polling booths, to get the poll workers, and to handle those elections. And big elections really put a focus on that.
What are a question we've got here? What are the typical grounds for contesting a will?
Typical grounds for contesting a will, the traditional grounds are usually threefold. One, to do a will, it has to be witnessed by two people, and it has to be properly witnessed and handled in a formal manner pursuant to statute. And so one of the traditional ways you challenge a will is that we would say lack of formalities, or that it has not been properly signed and witnessed. I say properly signed, there needs to be a mark. I won't get into all the details, but the best the best thing for a will is to have a signature, of course. Okay. But you actually don't even have to have a signature, but you do have to have a mark. But so the first, I would say, traditional ground for challenging a will would be lack of formalities, okay. Lack of properly preparing and signing that will and witnessing it. Secondly, would be a lack of what we call testamentary capacity. That is a particular mental ability that a person who does a will has to attain in order to do the will, and that is they need to be able to know what they're doing when they sign the will, mm-hmm. know the property that is in the estate, and know what we commonly refer into the law as the natural objects of their bounty, which is know their family and their next of kin and who they're going to leave it to. Okay. So the second one is called testamentary incapacity, and one other thing I'll say about that is the law recognizes that elderly people do wills, and so that is a very low threshold to be able okay. to appreciate your will and who your family is. And then lastly, which is the most common form of will contest, is where I live, a lot of my work is where wills are challenged on grounds of undue influence. And that is, there is a third party that is controlling, right. involved in the process, sometimes for good purposes,
right,
many times for bad purposes, and that is where most of the will contest litigation occurs.
We've got to step aside to take our first break, but we're going to pick up right here whenever we come back. Would love you to stay with us as we head to break. A reminder of how you can join our conversation. If you have a question you'd like to get to us, here's how you could do so. Also, you can find the firm on social media, Facebook, Twitter, as well as Instagram, how that can benefit you greatly. Those details coming up after the break.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Talking about probate litigation on the show today. Would love to have you be a part of the conversation. Don't forget, attorneys from Hollis Wright standing by live all throughout the program to take your call as well. That's a free, confidential, all-fair conversation that would take place. Is going to be going on until the program ends, so take advantage of that. One of the kind of the purposes, Carter, of this program for you all, I know you say it quite often, is to educate and inform the public. You not only do that with the show, you do that with social media as well, but a neat contest you guys have going on, an opportunity just to kind of expand that footprint and a cool giveaway.
Well, that's exactly right. There are two reasons why we do this contest periodically, and that is, number one, to say thank you to the viewers for watching and supporting the show, and number two, we want to provide the viewers and the general public with a different alternative platform to the show in order to get the same or equivalent type of legal information. We provide a lot of information on Facebook relative to what the Consumer Product Safety Commission is doing, regulating dangerous and hazardous toys and products. The FDA, Food and Drug Administration, we're constantly posting about drugs and medical devices that have been withdrawn or recalled from the market because of dangers. The news like that sometimes people would not get otherwise. And so we're posting those types of activities and things on our Facebook account. And today, or this time, we want to try and give away, or we're going to give away, an Alexa Echo Show system. Very entertaining. A lot of home information can be gathered from Alexa. It's a very good educational tool that you can use with your kids. And the way we're going to conduct the contest, as we typically do, is all the viewer or anybody in the general public has to do is go to our Facebook page and like and share the contest post.
Okay.
And we're also offering it through Instagram. So if you want to enter the contest through Instagram, you can like and follow us on Instagram. You will be entered into the contest, and we will do a drawing on June 5th, which I believe is a Tuesday, at noon, and we will do it Facebook Live like we've done before. And so it's really a fun opportunity for us to give not one, but two of the Alexa Echo Show systems away.
Two chances to win. A neat deal here. And to find the firm on social media, probably the easiest thing to do is just search the firm name, Hollis Wright, and you should find it there. So a neat contest. Go ahead and tag a friend and get involved. Carter?
And Peter, you can enter as well.
Watch out! I would love to. I could use one of those.
All right. When we took the break, we were talking about grounds for contesting a will. So somebody has a will. you've got a family member or an heir that looks at it, it's not what they thought it was going to be. We've all seen those moments in TV where little Johnny goes into the hospital room when his mother's on her deathbed and slides a new will in front of her and gets her to sign it. And that's really kind of what you're talking about. And a lot of times the lack of testamentary capacity and undue influence, I think, probably go hand in hand.
They do, although a lack of testamentary capacity is often, more medical based and often really difficult. Undue influence is more where the human involvement or the bad human involvement occurs. But in order to, if that happens, and what to do about it is contact an attorney. And you have to check on the case, and there's two important things to consider here, because there's two avenues to contest a will. There's one avenue to contest a will before it has actually been offered for probate, okay? And if you learn about it, it may not have been offered for, offered, has not been admitted to probate. It may be offered in the probate court. There may be a hearing set for it to be heard, to be probated, and I say probated, to be deemed the official will of the decedent. That is one avenue, to contest that will with a petition of contest filed in the probate court prior to that will being admitted to probate. And that can be a matter of being knowledgeable about the filing and when a hearing is set. A lot of times there are some parties who may have a right to contest the will, but who may not be in the notification of a will being offered for probate. So sometimes that can be a difficult situation to know about that. The second avenue is, say you missed that opportunity. Once a will is probated, there is a second avenue to contest a will, and that is after probate, it can be contested within 6 months by filing a will contest complaint in the circuit court, not in the probate court. And so it's an unusual procedure where you kind of have two opportunities. You only get to use one of them, but you have two chances to potentially contest a will if you need to. Do all wills have to be probated in order to properly distribute the assets of a person's estate? Because I know there are many times out there where somebody might have a will, but they just don't have a lot in the way of assets to distribute, and they were going to leave it to one person. Is there a way to do that distribution without going through the formal process of going to the probate court? Usually not. It depends. If it's a very small amount, if it's less than $5,000 in a bank account, there are some statutes that can help you do that without opening a probate. But typically, if you have a situation where someone has assets in an estate, and the classic example is somebody has a $200,000 account in a bank in New York somewhere, and they need to get it. And we've dealt with many of these. The only way that you're going to be able to get that is to go open an estate and to get those assets and distribute through an estate. And if it's a will, whether you probate it, you do not have to probate a will. If you have a will, you are not required under the law, I have this a will, therefore I'm duty bound to have to take this to probate and probate it. If you don't have assets in your estate, there's no need to probate that will. But, and a lot of people get confused about that. They feel like they're under, a duty. But typically, if there are assets in the estate and you want those terms of the will to be followed, i.e. it leaves it to Carter instead of Peter, Carter's going to want that will probated. Right. And now, if Peter has that will in his possession, I've had some cases like this, Peter may not broadcast to Carter that he has that will. And maybe Peter would rather it be a non-will estate where Peter and Carter split it. Right. Things like that happen. But if one is required to produce a will, if Carter tells Peter to produce a will as a matter of law, Peter would then have to produce the will, because the will can be a governing instrument of the estate.
All right, and that's a good segue into my next question. Do we have to go to a break?
Can we go to a break real
we
quick?
can go to a break, and then we'll come back and talk about what to do if you don't have a will and somebody passes away.
That's excellent. We'll pick up right there with that question, our final break of the evening. As we do so, a reminder of how you can get in touch with us. All that information there. Stay tuned. The final segment of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright. As with any industry, it's important in the legal world to hire an attorney that is knowledgeable and has a track record of success. But with so many attorneys out there and so many different types of cases, how does someone decide the right lawyer to hire? In this week's Legal 4-in-1, we're answering the question, what should I consider in hiring an attorney? In-state versus out-of-state, big firm or little firm, recommendations from friends or family, the internet, the phone book, or TV. With so many choices and so much information, it can be an overwhelming task trying to make the right decision. To complicate things, choosing a lawyer is an important and sometimes life-affecting decision and should not be taken lightly. So how do you select an attorney? First, do your research. Look the firm up on the internet. Learn about the cases they handle and the results they get. Second, find out what clients are saying about the firm. Many websites provide client testimonials or have a star ranking system. Use those to your advantage. And finally, talk with a lawyer from their office and ask them questions. Questions about the volume of cases they handle. Do they return phone calls? Are you just a number or a client that gets the attention you deserve? Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys right here on WVTM 13.
Welcome back into The Attorneys, our final segment here. Only about 7 minutes remaining in the show. Time really flying here, so if you want to take advantage of the opportunity to speak with attorneys from Hollis Wright standing by live right now, you got about 7 minutes to do so, so go ahead and pick up that phone and give them a call. Carter?
Peter, there was a firm fact that we displayed just a minute ago, and it indicated that once a will is revoked, it may not be forever revoked. Can you explain what that firm fact means?
Sure. Oftentimes there can be a will in existence on a certain date, and then at a later date in time a new will be drafted, and oftentimes the new will have a provision that revokes all previous wills. And as a result of that new will, it will create a revoked prior will. However, if the new will is later determined to be subject to undue influence or testamentary capacity problems or formalities weren't followed properly, and it in itself and in its entirety is set aside as a matter of law, that once revoked will, that previous will, can then come back to life to govern and serve and be admitted to probate to control the disposition of the estate assets.
Okay. And along those lines, oftentimes there are many people out there that don't have a will. And so what happens in the state of Alabama if a person passes away without a will and they have personal assets that need to be distributed in some way, shape, or form? Talk a little bit about how that distribution is done in a general sense, because I know it can get a little complicated. And then also talk about the process that that will go through in terms of the probate court and how it differs from somebody who is probating a will.
All right, I'll try and do that. First of all, with regard to a non-will estate, we call it an intestate estate, that is governed by a statute. Alabama legislature has a law that says if you don't have a will and you die, even though the decedent may have wanted to leave it to her, oldest child and to ignore the other 3 children, that means nothing. It will be governed by a statute, and the typical example of that is when a person dies and there's a surviving spouse. I'm using this most common example. There's a million different next of kin scenarios, but a surviving spouse, the surviving spouse, if all the children of the family, will get the first $50,000, the statute says, and then the balance of assets gets split between the surviving spouse and all the children. Whether anybody likes it or not, the statute governs that.
So the spouse would then get the remaining 50%, and if there are 3 kids, those 3 kids would split the other 50% equally.
That's correct in that example. And as for the process, it's very much the same process in regard to opening an estate. It is a petition for letters of administration instead of a petition to probate a will and a petition for letters testamentary, which is for a will. Where a non-will is, it's a petition for letters of administration. But there are some differences with a non-will where you get letters of administration and intestacy. You have to post a bond, and you have to be a person of good credit to become the personal representative of the estate. And you can have you are controlled as to how you administer the estate by statutes, again, that tell you how an intestacy is to operate, as opposed to a will where the terms of the will tell you how to operate the estate. So there can be lots of differences between those two. One of the biggest, though, is the fact that you have to post a bond, and that can be a big deal in the world of estates.
And there's a lot of confusion out there. We've covered some of this topic before on other shows, and we actually had somebody called in. They were scared to death because the person died without a will, and they thought that all of their assets were automatically reverted to the benefit of the state of Alabama.
No.
And so we were able to correct them on that point.
No, that only happens if there are no next of kin in a substantial manner. It's rarely seen.
Yeah, this is one of those things where there's a lot of rumor out there of what happens in these horror stories. I think that scares folks like that. Right. We have less than 2 minutes remaining. Just enough time for you, both of you gentlemen, with a final thought. And Peter, if you would, you go first, please, sir.
Sure, I'll be glad to. Thank you guys for having me. And one thing I would say is that in my world, I get to see a lot of family relations on display. And what I would think, if I have a point to sum up, is to tell people with regard to their estate and their estate planning and their wills before you get there, because I'm dealing with live people right now watching the show, is to consider real serious communication with your family. I know that sounds trite, but I deal with so many family difficult dynamics where that communication does not take place ahead of time, and it can be very hard. And one case in point would be businesses that are in a family. You need to talk about how you're going to dispose of those businesses ahead of time.
And you've seen families get torn apart from it as well.
Very much so, and I tell people that I consider myself a quasi-family therapist, jokingly and seriously sometimes.
Yeah, so. About 45 seconds.
Yeah, communication is the key, and record keeping is the key. If you're trying to decide how you want your property to be distributed, talk with the family members as they get older. Make sure everybody's on the same page about how the distribution is going to take place and who's going to be in charge of being the representative of the estate.
Great advice. Appreciate both of you being with us. Thanks so much for the time. Appreciate you being with us as well. We'll look for you next time. Thanks for being with us. We'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.